having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Your argument in number 19-2327, Cardenas Martinez v. Garland. And Mr. Chang, we are pleased to have you.
Frank Chang for petitioner Elvis Cardenas Martinez. I reserve 3 minutes for rebuttal. Elvis came to the U.S. as an unaccompanied child. He suffers from, although Elvis's lawyer, Ms. Moss, had ample indicia of these conditions before the immigration court hearing, she failed to seek procedural safeguards petition for 2 reasons. First, as to the issue of new evidence, the board failed to explain why the new state court order of incompetence and Dr. Feliu's diagnosis were not material. That unexplained conclusion requires a remand under Chenery and Ken. Performance was neither deficient nor prejudicial. That was an error. Ms. Moss prejudiced Elvis by failing to raise critical procedural and substantive arguments, especially given that her client was incompetent and had a visible disability. First, I would like to turn and begin with, this is a discrete issue, and regardless of how the court rules on the ineffective assistance issue, the court has to send it back because the board failed to explain why it rejected Elvis's new evidence. In support of his motion to reopen, confirming Elvis's cognitive disability, competent by clear and convincing evidence. Elvis asked the board to reopen his proceedings.
How did the new evidence with respect to mental competency speak to the issue of whether the time of the removal hearing, because as a general matter, when you assess competency, you are at the time of a removal hearing. In the case, evidence which came in a good bit after the fact, speak to his competence at the time of the actual removal hearing.
The question goes more to the substance of the materiality analysis. Our primary argument with respect to the new evidence issue is that the board failed to explain why the new evidence was not material. So we don't know what the board's position is on this issue, and we'll have to send it back for the board to give a reason why. And the second, more directly to your point, Your Honor, and again, it's not directly before this court, as to the materiality issue, this is an evidence of conclusiveness. Dr. Feliu found that Elvis has severe problems with his executive functions, and it's.
Well, let me ask you this, counsel. If the statute were a disability, your point, but even with the new evidence, under the specific terms of the asylum statute, because you'd still, in a motion to reopen, have to prove that you were a member of a particular social group that you're claiming and any sort of persecution. So while as an abstract matter or as a general matter and as a concrete matter, I'm certainly sympathetic to anybody that, but it is a question of how this fits into the terms of the asylum statute, both to the presence of persecution and to whether the persecution was somehow caused by the.
I think the more substantive analysis part of Elvis's asylum claim, I will address that as we talk about the prejudice caused by the ineffective assistance. However, as to the new evidence and the Chenery issue, what we are concerned here is that the board gave no reason why. The board simply, if I may direct your honors to Administrative Record page 6, then by the board asserting that the new evidence would not have changed the outcome. And we simply are not at a place to review.
Conclusory sentence, but I did have, I think my question relates a little bit to Judge Wilkinson's question. It just seemed to me that it's fairly evident that what the board meant was, look, there may be more evidence of the intellectual discase. I actually, it seemed pretty clear the board was just saying, look, you have more evidence going to the disability end of things, but not the agency's path under Chenery.
So I think the problem here is that the board did not consider the conclusiveness of the diagnosis that Dr. Failure proposed.
Why does that make a difference to the nexus analysis?
And I'll move on to that right now, Your Honor, and address the prejudice as to sort of the MAM issue and the mental incompetency. So we believe, so Elvis was prejudiced by the simple fact that he testified on stand, and the IJ's denial of the nexus was grounded in his own testimony. And during his testimony in the hearing, Elvis noted that he can't think of being an incompetent person who should not have testified in an adversarial hearing, testified thereby prejudicing his own nexus argument. And had there been a more robust request for allow Elvis to proceed simply on the basis of
with respect to the MAM safeguards, what more did you want than the big MAM safeguards is that you get to raise the issue of competency. Best able to judge competency would be both the petitioner's own counsel and the IJ. The proceeding and counsel in interviews found him to be engaged. And so I'm wondering the issue of competency, and I'm wondering whether on that issue, why we should override the views of both counsel and was attentive with respect to the removal proceeding. Why they're the ones in a much better position to judge, and they actually explored the very issue that the MAM safeguards speak to.
Certainly, Your Honor, I have two answers to that. The first is that I respectfully disagree with your characterization that what the IJ did here conformed with what MAM required. As Elvis submitted in his first 20HA letter back in May 2020, there was a Ninth Circuit decision that basically found problematic a similar kind of series of questioning and then finding of competence. What MAM requires is sort of a holistic review of available record at the time. And here the IJ didn't even have the time to review the evidence. Ms. Moss made no motions. So the IJ simply relied on the questioning. And even the questioning itself was problematic because there, Elvis could not understand the adversarial nature of the proceeding. He thought that the DHS attorney was there to assist him in his case, even though she was there to prosecute the case against him. The second point is more important, is that we're not directly concerned with the IJ's actions here, although we are concerned with it. We are primarily focused on what Ms. Moss should have done and what a reasonable attorney.
Counsel, this is Judge Harris. I just want to clarify one thing that you just passed on quickly. So whether the IJ was right or not about competency, that wasn't in front of the BIA on reopening, and that's not in front of us, right? I think I'm just saying what you were about to say. What's in front of us is just the ineffective assistance claim, but there's no challenge in this posture to whether the IJ abused discretion in finding competence. Is that right?
That's absolutely right, Your Honor.
Okay.
And what a reasonable attorney would have done when she has witnessed this confused colloquy between the immigration judge and her client. And she has, and also in addition to that, Ms. Moss herself even had submitted prosecutorial discretion requests to the DHS based on Elvis's mental frailty. I mean, she noted to the government, this is 3 weeks before the hearing, she noted that Elvis has some mental issues, is frail, it requires a further examination to know what's truly wrong with him, and that the asylum interview with the government didn't go well because of his conditions. I mean, a reasonable attorney in that situation, going into a removal hearing and just witnessing a confused dialogue with the immigration judge, I would have objected, would have moved for MAM at the time, but Ms. Maas did not do so.
Can I don't want to take you off course, but if I could just go back to your first argument for 1 minute about the new evidence and the failure of the explanation.
Yes, Your Honor.
Given that I now better understand, we are not directly confronting the question of whether the IJ was right or wrong when she found the petitioner was competent. So what is the relevance of that new evidence to what we're looking at now? It can't really go to ineffective assistance because it wasn't in front of counsel at the time. Counsel didn't have access to that information at the time. And since we're not looking at the correctness of the competence determination, and because it doesn't bear on nexus, what would be the relevance of that new information?
No, thank you for that, Your Honor. So there are essentially two separate motions to reopen before the board. They are independent and independent of each other. And so the motion to reopen based on new evidence would stand or fall on its own without any reliance on the motion to reopen based on ineffective assistance of counsel. And that is the same going the other way too. The motion
right, but even if we thought that information had some bearing or relevance on whether or not petitioner was competent at his hearing, that question is not in front of us.
That's correct.
So the information would have to be relevant to something else about the asylum claim.
Correct, Your Honor.
Okay.
And that goes to the materiality, which the board did not analyze or explain. And if I may just briefly address the TIMU issue in the remainder of my time.
Before you go off of that, I want to just follow up on Judge Harris's question, because I think the underlying difficulty that you have is that under the terms of the asylum statute itself, and that's what you're seeking, is a motion to reopen an asylum determination. There seem to me to be several problems with it. One is the particularity problem as to how this gentleman fits into the particular social group, and what the particular social group is. And then the other is what Judge Harris has identified as a nexus problem. Where is the persecution to begin with, and how is the nexus requirement satisfied so that we can assure ourselves that the persecution, whatever it was or might be, was undertaken on account of some protective characteristic. So the problem is that the underlying asylum case is vague, and it doesn't easily map onto the terms of the statute in terms of particularity and in terms of persecution and in terms of the nexus that the persecution bears to a protected characteristic. And that I think, because it's not that you don't have a sympathetic client, you certainly do, and I think we would all respect that. But in terms of the statute, the underlying case seems to me to have some gaps in it on nexus, causation, particularity, the name of the actual presence of either past persecution or a reasonable fear of future persecution. All of these things bear question marks. And that's where I'm having basic difficulties.
Absolutely, Your Honor.
You see what I'm saying?
Absolutely. I see that I'm over time, but if I may help to address those points, I'll be brief.
Yes, you may. You also have time for rebuttal, but why don't you go ahead and address the point now, too?
Yes, Your Honor. So I'll be brief. As to the particularity concerns that you raised, with respect, TIMU is a binding decision in this court. And as this court interpreted the asylum statutes in TIMU, and it's the particularity can be specified to specific illnesses that end in visible disturbances, that end in erratic behavior. And there's a reasonable likelihood that Elvis can muster up enough evidence and arguments to other people that's going to cause prejudice to people who don't understand what epilepsy is. And as to the persecution and the nexus and all of those issues, Your Honor, attention to AR pages 57 to 61. It's an exhibit list in support of the motion to reopen, contains country condition evidence showing how mentally ill people are being stoned to death and they're shot and they're labeled loquito and they're often liquidated. I mean, there's an instance of a person getting burnt because they're mentally ill. All
right, well, thank you very much, Mr. Chang. And as I mentioned, you have some rebuttal. And Judge Nguyen, do you have any questions, or Judge Harris, do you have any further questions of Mr. Chang?
I simply wanted to, when you come back on rebuttal, as I look at this case and what is here, it is the ineffective assistance of counsel claim that you make dealing with this attorney's failure to seek the procedure safeguards that are guaranteed to mentally incompetent non-citizens. If we turn to the board's decision, the former decision, a matter of MAM, it just seems to me that's a particularly strong argument. I'm not putting down the argument with the team or even with the new evidence, but the new evidence is, it may or may not be there, but simply the attorney's performance in this case. There are particular cases that deal directly with this, and it looks rather abject to me. But when you come back, if you will focus more on that, I would appreciate that.
Thank you, Your Honor.
Judge Harris, do you have any further questions of Mr. Chang?
No, thanks.
Judge Wilkinson? Judge Wilkinson, this is Sarah, the conference manager, and we're having an issue a little bit with Judge Harris's phone. I've asked Ms. Byram to unmute.
May it please the court, I am Sarah Byram, appearing on behalf of Merrick B. Garland, the United States Attorney General. Did the board abuse its discretion in denying reopening based on alleged ineffective assistance of counsel or the proffer of non-influential new evidence? In both cases, the answer is no. Petitioner was not deprived of a fair hearing or was prejudiced, particularly because the immigration judge conducted a competency hearing consistent with MAN, which petitioner has never challenged and can no longer challenge because the time for a petition for review of that decision has run. In fact, petitioner's claims on appeal face two hurdles. One of them being that petitioner was given the competency hearing by the immigration judge. And the other is that he never explicitly identifies the safeguards he believes he should have received. The only one he consistently alludes to is having his mother.
Counsel?
Yes.
Counsel?
Yes.
Oh, sorry, it's Judge Harris. You've already talked very briefly about the prejudice question, but could you address counsel's actual performance at this hearing, which seemed to be where the BIA was focused, and the BIA seemed to be of the view that because after these proceedings started, counsel filed a letter saying, I had no reason to think there were any cognitive impairments, that was sort of good enough to show that there was no deficient performance, notwithstanding the fact that about 2-3 weeks ago, she had written a letter saying, no, he had all kinds of cognitive impairments. He's childlike. He can't possibly do something like this. And the BIA never addressed that. So is the government's position that the performance here was okay or not?
The government's position is that, yes, that petitioner's that petitioner's formal counsel's performance did not prejudice him or render the hearing unfair. And this is for a couple of reasons. First, because the immigration judge gave that MAM hearing, that really takes the wind out of the sails, I think, of the ineffective assistance of counsel claim, because he essentially received, what he's claiming he should have received. And, we're
so
looking
is your
to
emphasis, excuse me, counsel, is your emphasis on the performance prong or the prejudice prong? Which one of those do you lay the most emphasis on?
Both of them at the hearing were acceptable. And if I had to choose one, I would say the prejudice prong, because there's no evidence in the record that he was prejudiced because he got the hearing by the immigration judge. And petitioner sought to present this asylum claim, and his counsel reasonably assisted him in presenting this claim where, remember, he's the only individual who has any evidence and knowledge of the asylum claim that he's trying to present.
So it would seem to me that the prejudice prong, as you've explained it, has two aspects to it. One aspect of the prejudice prong is a procedural aspect, and you're making the argument that the IJ did provide at least one of the MAMC safeguards by virtue of the colloquy. And the second prejudice prong is more of a substantive prejudice prong, which goes to the infirmity of the underlying case with respect to nexus and particularity and causation, which is, I guess, another way of saying nexus. So as I understand the prejudice prong, it has both a procedural and substantive aspect to it, does it not?
That's correct. But he also wasn't prejudiced in a substantive manner, because for two reasons. One, when you look at the hearing transcripts, it's clear that he was able to understand the question being asked and to give a responsive answer. His testimony doesn't conflict with his affidavits. The immigration judge found him credible. And in addition, the safeguard that petitioner alleges most frequently petitioner should have gotten was that his mother should have testified on behalf of petitioner. But it's hard to see
Well,
how his mother testifying instead of petitioner would
Counsel,
have.
can you hear me?
Counsel, excuse me, Judge Wynn has a question.
Can you hear me?
I can, yes.
I wasn't sure. You kept talking when I was talking.
I initially couldn't hear you, so.
Okay, well, let me, can you hear me now?
I can, yes.
Thank you. So we are talking about the IJ's hearing, and if you look at what he actually did, these are mostly leading questions, yes or no. And let's be clear now. Everything has indicated if you move outside, this guy is absolutely incompetent mentally. Let me just tell you right now, I'm looking at the medical records, I'm looking at all the testimony of the experts, that's there. You have an IJ who conducts a minimal hearing, yes, no questions, and he never looks at those medical records. That cannot be enough to satisfy MAM. You go to the mother in the instance. The counsel's answer to why the mother can't testify is she has hearsay. Well, that's not relevant. Hearsay is admissible in these type of hearings. We know this. But the mother knows this young man. Even the judge himself asked this counsel, why didn't you call the mother to it? Only he testifies. This does not shed any light on whether this petitioner actually understood the nature and the purpose of the hearing. It's abominable what occurred here. This counsel was as deficient as I've ever seen. She did absolutely nothing, and she knew this. As Judge Harris has pointed out, she's already said it. Then she come back and refute and say she didn't say it. But this evidence the evidence was replete that this guy had a mental problem. And the rules are fairly well set that when we're dealing with a non-citizen in these type of situations and competency becomes an issue, there are safeguards. And we as judges can't we could nuance this and figure out all kinds of procedural ways to get around it. But the facts, as Judge Wilkinson recognized, are rather stark here. And I don't think we are so hammered so restrained as judges. We have to shut our eyes to what these facts lead to and what actually occurred here. It was a minimal hearing. It was nothing but yes, no answers to someone who barely understood. Obviously, in a previous hearing, they had to dismiss it because they said he wouldn't answer the questions. He said nothing. He just sat there and just starved. And so this is where we are. The question here is that enough for MAM?
Well, with all due respect, the immigration judge was aware of petitioner's medical records, which is why.
Tell me where that is indicated in the record. Tell me where that is indicated that the immigration judge took in consideration what is in those medical records.
In the transcript, she does indicate that she is aware, which is why she, on her own affirmatively, undertook a competency evaluation of petitioner. I would note, though, that as opposing counsel has stated.
Now, when you say she undertook a competency evaluation, we're talking about a hearing now. Evaluation, you're certainly not referring to any type of expert evaluation. You're simply talking about a procedural hearing in which he's afforded an opportunity. But there's no evaluation that they undertook. The medical records speak for themselves.
The immigration judge conducted an inquiry that was consistent with MAM, but that issue isn't before this court because the petitioner has never timely filed a petition for review of that decision of the underlying merits. So to the extent that
MAM places an affirmative duty on a lot of folks there, and it's not just this counsel in there. This IJ received these records at the beginning of the hearing, and less than 10 minutes later, she finds him competent. So you're telling me she reviewed over 100 records of pages of record in that time? And the IJ received the records for the first time at the beginning of the hearing. She only knew of the fact that those records existed. She could not have known the substance.
The immigration judge, according to the transcript, went through and conducted it consistent with MAM. And I appreciate your frustration. Unfortunately, it's
Well,
not
I
an issue before this
don't want to
court
express
because
frustration. I want to deal with the facts. Let me make sure we are in agreement. She did just receive those records just at the time of the hearing, didn't she?
they were submitted, I believe, before the
At the
hearing
time of the hearing.
by
At the time of
petitioner's
the hearing.
counsel.
10 minutes later, she found incompetence. Is that correct?
I think the important thing is that there wasn't a petition
No,
for
I
review
want to deal
filed
with
of
that because
decision
you say that this was
by
frustration. I
petitioner
want to
at any
deal with
point.
facts. Please, let's deal with facts. I don't want to deal with frustration. I want to deal with facts. The fact here is she received these records at the beginning of the hearing. 10 minutes later, she gives a competent determination. That's 100 some odd pages. And there's nothing there to indicate that she actually knows the substance of this. She reviews them for the first time at the hearing and then gives a competency determination. And by the way, counsel, none of this is coming from counsel. I'm just dealing with facts. I'm not dealing with frustration. I don't want to deal with frustration. Frustration is when you personally feel something about it. This is not frustration. I'm dealing with the facts here. Well, what this woman did, she gets up and she answers these questions to determine his competence. She says, "Do you understand what the proceeding is about?" He says, "Yes." And that's it. To someone who the record indicates quite clearly he's mentally incompetent. And you see that's
maybe
enough
the
on the MAM.
reason that the hearing was, or the dialogue and colloquy was undertaken was because in reviewing the medical records, there was enough to persuade the IJ that I want to make sure of this and I want to satisfy myself visually in my own mind that this individual knows what's going on. But beyond that, I think it's important.
Well, Judge,
always in these.
From that, let us make sure we're in agreement because you've used the term she reviewed the records and she came to this. It is quite clear she only received these records at the time of hearing. If she reviewed it, it was only to get a light on. She has no knowledge of the substance of those hundreds of pages that are there. And if you look at the pages, there's no reasonable IJ that would not go further. I just want to make sure we're clear on that because I don't want to gloss that over as though, well, she reviewed the records. Yeah, if on the whole record, if we look at it, that's what it looks like.
Let's say that the records prompted her to undertake the colloquy, but beyond that, the point I was going to make was that I think it's always useful to ask who bears the burden of proof on these ineffectiveness claims. And it is clear that the petitioner bears a burden of proof both as to the competency prong and as to the prejudice prong. And if you bear the burden of proof on the prejudice prong, you would have to submit, it seems to me, evidence that counsel's performance in some way prejudiced the petitioner's case. But even on this appeal, I still do not understand with any precision what the persecution was, how the particularity of the particular social group should be defined, what the nexus was. All of these things are essential to establishing an asylum case, and the petitioner does bear the burden of addressing each one of those three factors, which are shortcomings in the asylum case. And I don't see in the record that those qualms about this, how this maps onto the asylum statute, have been addressed. And I agree with my good colleagues that with Judge Wynn that this isn't a matter of frustration. It's a matter of the facts and a matter of the law. And I am still scratching my head as to how this makes out an asylum case. And if there's not some on 2 or 3 months, I don't see where the prejudice attaches. And it is a question on which petitioner bears the burden. And, sometimes in these immigration cases, you feel, and I feel at least pretty torn, because as a general matter, so many of these cases have very sympathetic elements, and this is surely one of them. But at the same time, the asylum statute, as we've said many times, is not a general hardship statute. If it was a general hardship statute, I would say, well, this individual it appeals to my sympathies and tugs at my heartstrings. But how do I get to it as a matter of law? And that's basically where I'm having a difficulty.
I want to add also to Judge Wilkinson's statement. I agree there is a burden of proof regarding ineffective assistance of counsel or asylum. He doesn't have a burden of proof that he's held to show he's competent, though. That's a whole different matter there. So when the IJ undertakes this hearing to determine, there is no burden on him to show he is competent at that point. Burden is a whole different ballgame. And here, when you have an IJ that has all these medical records before them, and we're dealing with the MAM, which is, I think, if we focus on that particular board precedent here, at least for this hearing, that's the kind of safeguards we're talking about. And when we get into the whole business of asylum, there are certain things that we take, at least in the determined from the beginning. One, he claims he is a part of a social group. He's part of the Honduran children lacking effective parental familial protection, and those who suffer from epilepsy or seizures, and children who are disabled and who lack effective parental familial protection. And so when you move from that, if whether we're going to make that determination at this point or not is one thing, but the determination of whether or not the competency is there is clearly before us. And so what that leaves us, and why these are difficult facts, is because, the remedy is pretty simple. Send it back and let's do this thing right. This young man is by all accounts incompetent, and somebody didn't do their job. It's very obvious this counsel was deficient in so many ways. And there are burdens that AMAI place on the IJ as well. It's almost like an Anders type thing with us on criminal cases. You can't just sit back and conduct a hearing and with blind eyes and get a medical record in that's 100 and some odd pages and then blow through it in 10 minutes and says, okay, he's competent, and this guy is barely answering any question you're asking, yes, no questions. And then it comes up to here, and then we look the other way and wade into, well, it's not prejudice, we didn't do this. Clearly there's something wrong with this case.
If I could just respond to that with a couple of quick points. First off, it's important to keep in mind also that petitioner has never disavowed any of his former testimony, any of his former statements. He's never explained how his testimony would be different, what he would have said that was different, what events weren't described accurately or meaningfully. In his claims, he's never changed any of his former testimony, took issue with any of it, never disavowed any of it, and never quibbles with any of it, first of all. And second of all, if we look to the safeguard that he keeps talking about, that he says that he should have gotten, if, my time is finished, if I can continue just briefly. If we go back and we look at the safeguard that he raises most often, and he never explicitly identifies clearly, I wanted this safeguard, this safeguard, this safeguard, this is what I should have got, and this is how it would have changed it. He never sets that forth. The safeguard he says most often is that he would have been excused from testifying and his mother would have testified on his behalf instead and presented his claim. Admittedly, it's hard to see how his mother testifying on his behalf would have presented a stronger claim or would have resulted in an asylum grant, mainly because his mother wasn't in Guatemala for the duration of petitioner's life in Guatemala. She has no evidence, direct evidence, she wasn't there for his life in Guatemala. She doesn't believe some of his claims about the abuse that was suffered by his aunt, which, moreover has a nexus issue there, but she doesn't believe his claims with his aunt. She lacks the knowledge. And so it's unclear how his mother testifying would have established a claim when she didn't have direct evidence or knowledge. Excuse me? Just barely.
No. There is a can you hear me now?
Yes, it's better.
Can you hear me?
Yes.
Okay, I haven't moved or anything. Okay. Here's my question. What is your understanding of the grounds on which the BIA itself denied this claim? We have to review the BIA's decision, and I feel we've been having a very wide-ranging discussion about prejudice and performance here. What is your understanding of the decision by the BIA that we are reviewing? I read that decision and I see much discussion about why counsel's performance was not inadequate. And I see much less about prejudice, and I don't see anything about, well, even if he had prevailed upon the IJ to give him the accommodations that we're talking about, where he doesn't testify and the mother comes in to testify, that wouldn't have made any difference. What is it? We can't come up with our own theory. We have to review the BIA's theory. So what is your understanding of the ground on which the BIA rejected this claim?
Are we talking about his new evidence or the ineffective assistance of counsel claim?
No, I'm talking about the ineffective assistance claim.
Well, the board in its decision does go through a number of things. They do talk about the fact that the petitioner argues that she provided ineffective assistance of counsel by failing to bring his mother into the hearing. And that's one portion that they reject.
I'm sorry.
Not showing
I'm sorry,
prejudice.
counsel, can you hear me?
I can.
Can you hear me, counsel?
Yes.
Great. So I'm not talking about the claim of ineffective assistance for not bringing the mother into the proceedings. I'm talking about the basic claim of ineffective assistance for failing to raise the MAM safeguards, to ask for the safeguards.
Yes.
What is your understanding of the ground on which the BIA rejects that claim?
Well, one reason that the board has rejected that claim was because they, and I'm just pulling out my decision, was that he got the hearing from the immigration judge, and that going further than that petitioner doesn't actually show that he was prejudiced by not having her ask for those safeguards. And the board gives three, they talk about the mother in the hearing and also Tamu and things like that. But the board explicitly says that petitioner wasn't prejudiced by not explicitly asking for the MAM safeguards because of the mother testifying, and also because of the fact that that the immigration judge had done that competency.
Well, I want to ask a question regarding that. So in the opening brief of the petitioner, he states that he would have asked to have his testimony waived because the most critical prejudice was the fact that he himself had testified. So he would state that his testimony was not helpful, accurate, contrary to his counsel's claim. And had this mother or other witnesses, including experts, testified on his behalf, there's a reasonable probability he could show at least a 10% chance of being persecuted on account of his membership in a particular social group defined by cognitive abilities, disabilities. So I think when I see a case of this, I see a case of a reasonably competent attorney would have solicited expert testimony regarding the petitioner's conditions and the conditions in Honduras. And that happened in Timok. There were 2 experts who testified in that case that provided crucial support for the petitioner's asylum eligibility and a showing of nexus in Timok. So again, the petitioner doesn't need to show a conclusive showing here. The prejudice standard is akin to Strickland. And where there's a probability sufficient to undermine the confidence in the outcome, I think the answer is clearly yes. And so given his significant disabilities and the fact that his testimony is the only basis for his claim, he has significant disability and his testimony is the only basis, I think that the lack of safeguards undermines the confidence in the outcome. We've spoken of prejudice. I think there it is.
Then with respect to that, though, it's specifically on the nexus point, though. I mean, first of all, it's hard for me to see, and petitioner hasn't really, I don't think, fleshed this out, how having his mother testify instead of him when his mother wasn't there for 14 years, they never lived together, how she can more effectively present a claim she wasn't there for. But with respect to the nexus,
the larger point, though, I think, in addition to that, is that
because it's not,
you're going to bring forward, if you have the burden on prejudice, you have to have some specificity to what you would have done differently, both with respect to what evidence would there have been of persecution, what evidence would there have been that that the persecution bore some sort of nexus to disability, and you have to be at least somewhat specific on that. You can't just say, I would have done it. You would have said, well, here are the experts we would have brought forward. Most of the cases on prejudice where we found a reasonable probability have been much more specific as to prejudice than this one is. And you have to say, look, here's the difference it would have made. And you have to be at least somewhat concrete and to present, at least to give the court some reason to believe that there's a reasonable probability. But that's one of the things that's lacking here, and that is exactly how is all of this going to make a difference? I mean, we've talked about this, we've talked about that, but at the bottom of it all is, even if you assume arguendo that there was a failure on the performance prong, how is it going to make a difference? And you can't just say, well, it might have, it would have, I mean, there's got to be something concrete.
Well, I think that's exactly right. I think petitioner says the safeguard that I would have done is my mom would have testified instead of me. But they never explain how the mother's testimony would have established the asylum claim for him, particularly when she wasn't around. But I want to be clear. I want to be clear in terms of where we are here and when we're looking for specific prejudice. If you have an individual and that individual is the only person who testified, and then he says, well, you know, I want that needs to be waived because it is the critical part here
The critical prejudice is the fact that he himself testified. And he has disability. He has cognitive disabilities proven right there. And so what he's telling you is that there is as in TIMO, go to TIMO. TIMO, we are bound by 2 expert witnesses provided that critical support for the petitioner's asylum eligibility and a showing of nexus. There it is. It's in TIMO, and we are bound by that case. A reasonably competent attorney would have solicited expert testimony regarding the conditions and the conditions in Honduras. So the petitioner, as I said before, doesn't need to show a conclusive showing here. He needs only show a probability sufficient to undermine the confidence in the outcome. And there's the answer. Given his significant disabilities, he's the one testifying. It is his testimony that's doing this claim. And if we do the safeguards on the MAM, there it is. There's the evidence. There's that specific evidence you're looking for. There's the prejudice you're looking for. It is unlike other cases because this individual has significant cognitive disabilities, and it's his testimony. No one else. Doesn't call the mother, and while you put down the mother's testimony, it's done all the time in immigration cases. There's no rules of evidence controlling what she's saying. Who else knows more about this young man than this woman who is in the house with him, can testify to his cognitive abilities, can testify as to what even the immigration judges pass it at. You can dismiss it all you want, but these cases, no competent attorney would not have called this mother to the stand from that perspective. So it's not like her testimony is a throwaway that, oh, what can she say? She doesn't know anything about Honduras. She can say what other witnesses can say. She has a better view of it than the immigration judge in terms of things that are going on there, and it's evidence that would be helpful in terms of the outcome here.
Judge Wynn, with all due respect, I'm not saying that her testimony wouldn't have been helpful, but it would have been the only testimony of his claim, discounting experts who, that's an expert testimony, because it's not as if she would be testifying in addition to petitioner. She would be testifying in his place. Well,
you understand, if you understand what I'm saying, we're dealing with petitioner's testimony. And that's where we're probably having our little disagreement here, and with respect to my good friend, Judge Wilkinson. And that is, it's petitioner's testimony. He has the cognitive disabilities. He doesn't understand anything from what the medical records are showing here. And he's getting these leading questions that are coming there. And you look at the whole record here and you determine it is his significant disabilities and the fact that his testimony is the only basis for it, that you then come to conclusion that the safeguard has been undermined in terms of the confidence of this outcome. That's all you need. You don't need a conclusive showing.
If I can just add 2 final points. One is which I think it's important to keep in mind too, that petitioner was an adult when and I understand that there are these other issues at play, but he was an adult at the time that he expressly indicated to his counsel many times that he didn't want his mother to testify. He didn't want her in the courtroom. He had a strained relationship with his mother. So that also plays into this situation, and in petitioner's former counsel's representation of her client, in that he specifically indicated many times that he didn't want her to testify. And so that has to be, looked at as well. And I would note that petitioner's medical records do indicate that his mother lacked knowledge about his medical, social, or developmental history. So
does it matter if he's an adult? Let me ask this question. If he is incompetent, does it matter that he's an adult?
Well, at the time of his hearing, he could make decisions, and I think that
well, I understand you say that, but nothing in the record says that. Nothing in no medical record, no expert has said that. You said it, and maybe some judges have said it, but it's not in this record.
but there isn't evidence that he was, 100% incompetent, that he couldn't make any decision of his own, including, I don't want my mother to testify. She doesn't believe some of my claim. And so I don't think that is something that can be easily discounted. Even if you consider some of his conditions, he was an adult at the time of the hearing. He did not exhibit indicia of incompetency such that he was unable to coherently, give his claim, proffer his claim, and indicate and express a desire that he didn't want his mother to testify. I just wanted to mention one quick thing about Temu. If I see my time is well over.
Well, the broader point is that we can't engineer all of these things from on appeal, and we're trying to say that, oh, well, he's incompetent or whatever. The people that had to say really that their assessment of this was incorrect. We can say, well, we have this circumstantial, they should have done this, they should have done that. The fact that they had eyeballs on the question and we don't, and we're trying to do all of these things from an aerial perspective, from way up, and we're trying to overrule the combined judgment of the IJ and counsel, who are in the best position to judge that issue. And that's just with respect to the performance prong. When you get into the prejudice prong, there are even more hurdles. But, it seems to me we're going round and round and round on this. But if Judge Wynn has any further questions, I'm certainly prepared to hold off and let him ask whatever questions he may have. Judge Wynn, do you have some further questions or comments you wish to make?
Thank you, Judge Wilkinson. I'm confident we've fleshed out our differences here. I don't think we've gone round and round. I don't think it's so evident that this is, when you look at the record, the medical records and what's in this case right now, one could, if you did not look at anything else, parse out the very, very minute evidence to show this man is competent and proceed on. And I think that's what's happening here. I don't think it's a round and round thing at all. I think it's just a matter of, we are court, we're judges, we ought to do what we need to do. It needs to be a fair proceeding. We ought not tolerate this, and we need to move forward. But I thank you for giving me this opportunity, and due respect to counsel. I know you're doing your job, but it's not frustration, it's the record before us. And I think Temu controls this thing, and I also think MA controls the ineffective.
Judge Harris, do you have some questions you would like to ask?
No, thank you.
I just wanted to raise
You
about
don't
PD.
have any further questions?
Oh, judges, your honors?
No, sir.
I just wanted to state that I know petitioner has raised prosecutorial discretion. I know that petitioner's claim or request for PD was denied in the past. And we're in a new administration now. And so we have, obviously, as you all know, there's some different priorities that are happening. But petitioner hasn't come forth recently, as far as I know, about prosecutorial discretion. And I'm just putting out there that that's obviously a request that can be entertained at any time. So if that's of interest.
I didn't hear that last statement. Was what?
The prosecutorial discretion, to say that to the best of my knowledge, petitioner hasn't re-raised that issue with either our office or the Department of Homeland Security, and just putting out there that that's a request that can be made at any time.
All right, thank you. All right, Mr. Chang, you have some time for rebuttal, so let's hear from you.
Thank you, Your Honors. With respect to the last comment by my friend on the other side, we're concerned with this record and what happened in this case with Ms. Moss. The new PD request is not relevant to this case. And I just want to kind of address Judge Wynn's last question to me. I'd like to point, Your Honors, to the Third Circuit's decision in Fatiga from 2007. I think that'll kind of help the court with how to analyze prejudice. And like Judge Wood noted, there was a specific prejudice in this case as to MAM issue, which is that Elvis ended up testifying. Once we remove that prejudice, I think there's going to be there is a reasonable probability that the outcome would have been different, and the Fatiga supports that outcome as well. In Fatiga, the specific prejudice was unfavorable credibility finding, stemming from inconsistencies in evidentiary submissions, which was prepared by a law student and not even reviewed by an attorney in that case. And the Third Circuit said that once you remove that critical prejudice, there's a reasonable likelihood that the outcome would have been different. And here,
but I'm still, I still come back to the same basic point. I don't understand what difference all this would make. I don't understand what exactly the persecution was, and I don't understand how the persecution was on account of membership in this proposed social group. I just don't understand. I don't understand what evidence you would have put on, what experts would have been put on. I don't understand what basis there is to identify. I don't understand how you would, if you got all the relief that we gave you, that you're requesting from us. I don't understand how you would establish the persecution. I don't understand how you would connect the persecution up with the membership in a particular social group. And sometimes it's a hard thing to stick with what I think are the textual mandates of the law in the face of what is clearly a sympathetic case. If I could rule with my heart, I would rule with you. But I cannot. I have got, I took an oath to follow the law and the terms of the law and the terms of the statute. And I don't understand how you could make what you would do to make the case under the statute as to past persecution, likelihood of future persecution, how that relates to disability. If that were put before me, fine, but I don't see it.
If I may briefly conclude, Your Honor, and respond. With respect, I point Your Honor to Blue Brief pages 44 to 46, where we discuss that issue, as well as Administrative Record pages 57 to 61, where we list the country condition where mentally ill people are treated badly because of their mental illness, as well as Administrative Record pages 1099 to 1101, where attorney Derek Hensley explains how he would have tried this case if he had Elvis as a client, and if a reasonable attorney had a client who had disability, how that attorney would have tried this case. Thank you, Your Honors.
Well, I want to add, if you don't mind, Judge, in light of your.
Of course, please proceed.
I just want to be clear in terms of my position on this. And this goes, I agree, we from a textualist perspective, those who choose to go that way, you have a certain, tie into how the statute reads, and consistency, whether in criminal cases or dealing with other issues that come before us, we need to be consistent in how to do it. There are instances in which we look to see what the situation is. In cases like this, it is often difficult to predict what kind of safeguards would have been actually granted and just how those safeguards would have affected this non-citizen's ability to prove the essential elements of his claim during a proceeding. So here, a counsel's failure to secure the procedural safeguards for an incompetent person is, in my view, is somewhat akin to a structural error that defines or defies prejudicial analysis from the stringent way in which Judge Wilkerson wants to hold right to the letter of the statute, and certainly it is there. I mean, it certainly is defensible. I'm not going to take that away from my friend at all. It's making a strong point. But because the lack of such safeguards here affects the whole framework from a structural procedure within the hearing proceedings, then that's the precise effects of this error that are necessarily unquantifiable and indeterminate. So I think that's where we are. And I'm okay with if we choose to be strict in our interpretation of statutes and the textual things. I just, as a judge, I want to see it done in all cases. I don't want special cases coming up with criminals and others in which we do it differently. But here we've done this, and we've done this in multiple cases of looking at it and seeing beyond here that there's a structural problem here. And it arises from this incompetency ineffectiveness in terms of the counsel here, and then the incompetency of the petitioner here. So I wanted to add that to the record because I want to be clear, Judge Wilkinson, you and I are not at odds in terms of the way in which you're approaching it. I fully respect the manner in which you're viewing this case, but I do think it is a very stringent way in which to do it, in which I don't think we should carve out. If we're going to do it in this case, let's do it in every case. And I know you believe in that too.
Yeah, well, to me, it's a very important thing that there's an abuse of discretion standard with respect to a motion to reopen. The motions to reopen are different, I think, from initial appeals from a denial of asylum, and they're under an abuse of discretion standard. And I think that has to mean something. But I guess what I want to say is my colleague Judge Wynn is just to thank him for this spirited discussion or disagreement, and just how much I respect the points that you've made, Judge Wynn, and I respect your eloquence and everything, and I simply regret the fact that we may have a good faith disagreement, but I sure do respect where you're coming from, and I want to, before I address counsel, I want to make sure that Judge Harris, who's asked some very pertinent and helpful questions, I want to ask Judge Harris, do you have any further questions you would like to ask?
No, thank you.
All right, I would just like to thank counsel, both of you, for your helpful arguments and the preparation that you've put into the case. And I'm sorry that all three of us can't come down and greet you, but we're very appreciative of your arguments nonetheless. All right, Sarah, we can now proceed into our second case.
Thank you, Judge.
To discuss number 192127, Dawson versus Washington Gas Light.
Yes, good morning. May it please the court. My name is Patricia Randall from Randall & Randall Attorneys at Law. I am representing Kyle Dawson, the appellant. This court's standard of review for the district court is de novo. Kyle Dawson has been a victim of discrimination, retaliation, and harassment. There are genuine material facts that will affect the outcome of this case that require a trial. We explained in our brief how we have put forth more than enough evidence to reverse the district court and defeat summary judgment. The heart of this appeal is to convince this court that context matters. The totality of the facts, viewed in the light most favorable to the appellant, shows that a reasonable jury could find discriminatory animus based on his race, color, and but for his protected activities and classes, he would not have been subject to all the adverse actions imposed by the appellee's closely knitted managerial team and human resource community. The content of this case focuses on appellee's unrelenting effort to discipline and adversely affect the conditions of employment for the appellate. He was the only biracial, light-skinned employee, crew leader in training, and crew mechanic at the Springfield, Virginia station, who engaged in protected activities and was disciplined for matters covert action should not be looked at in isolation throughout the irrelevant years. He was subject to hostile work conditions, which included several indirect racial comments and unwelcome behaviors. He was greeted with superficial responses by human resources on witness testimonies, who also attested to the discriminatory attitudes in the workplace. We believe that summary judgment was inappropriate for three primary reasons. One, the evidence and inferences were not viewed in the light most favorable to the appellant. Two, there is evidence to show pretext for at least 4 of the disciplinary actions. The suspension for unpaid paid time off, the suspension for striking an unmarked water line, a reprimand for being tardy, and the termination for unplugging his vehicle drive cam. And the court failed to rule on appellant's claim for discrimination.
I want to know why is this a Title VII case as opposed to a question of labor law and a collective bargaining agreement and the rest these workplaces have very, very detailed procedures set out for for progressive discipline, and they're often set out in a collective bargaining contract or whatever. And I guess I don't understand why this case wasn't argued more in contractual terms than as a Title VII case. I'm not sure why this is. I'm not sure why this is brought under Title VII.
I'd be glad to answer that. Keeping in mind that we are talking about 2 discrete time periods. One, in 2013, the first EEO complaint was filed. Subsequent to that, in 2018, the second EEO complaint was filed. The right to sue and the decision by EEOC was not made until 2014. So I believe that because of the hiatus, the second part of the matter dealing in 1917 to 1918 time period had been pushed forward to the collective bargaining agreement. As a matter of fact, for the most part, an arbitration was taking place. So we have 2 issues before us, the first part of the EEO complaint and the second part, and that may explain the difference.
But reading through the record here, it simply struck me that this is really just a case of an employee who had not just one, but a whole string of employment incidents, which range from relatively mild things like not reporting to work for time to some very serious things like running a red light in a work vehicle. And if you look at the drive cam, he almost hit 2 cars, and he's taking lunch breaks when there's an emergency gas leak site, which that's difficult to take. But I don't understand why, even if you were to view it in Title VII terms, why it seemed to me that the reason for the discharge was a repeated failure to follow all sorts of company policies. And I don't understand how that, which is clearly the company's view, and what makes the company's view pretextual. It seems to me that a lot of these incidents of disconnecting drive cams and running red lights and failure to go to the gas leak site, it seems explanation be pretextual.
Yes, Your Honor, thank you for that question. For the most part, the record will show that these actions were taken not because they violated company policy, but in fact because there was disparate enforcement of, he was not tardy and the policy was not being implemented consistently. One person was allowed to be tardy as often as he wanted, and appellant was in fact disciplined as a result of that because of his race, because of his biracial status, and because of his color. The second one, and the probably most egregious one, I'll jump to that, is the paid time off, where you actually have an individual, while you might call it unfortunate situation, we call it targeted discrimination, being discriminated because he didn't violate the policy. He in fact asked for approval to have time off, asked for approval from the supervisor on duty, was approved for that time, and still retaliated against and for the most part, put on another level of suspension so that he could ultimately, because of the progressive discipline policy, be terminated.
How did all this relate to race?
Well, the race is significant in that the disparate actions occurred because he was biracial in a class with a manager who we believe discriminated against him because he was biracial. And for the most part, told individuals and made derogatory statements relative to the fact that he was not supportive of people who were half-breeds. Also statements, and for the most part, statements were made that were supported by witnesses as to how he was being treated, and that was harassing and that was derogatory. It took place, and the next piece that we have is that that same supervisor decided that he didn't want him in the training program. So because of that, and again, because of the impact of progressive discipline, he went ahead and imposed another discipline on him. One, again, no policy at all, and that is striking an unmarked borderline. That has never been done in the history of the company. But this supervisor took it upon himself to discipline for that. And because of that, he was knocked out of the program. The program that, for the most part, that same supervisor had said he's not going to make it, and told his colleagues that he's not going to make it because he knew that after 3 strikes, you're out of the program. So he ensured that 3 strikes did occur. And we believe is because of discrimination and because of retaliation, because he actually opposed this action by the supervisor, spoke to this higher level supervisor who allegedly spoke to the supervisor in question. And right after that, he received the disciplinary action that I just spoke of. Then he's out of the program. And because he's out of the program, he is allowed to be away from the responsible management officials. He succeeds for the most part, except for one incident that happens, and that is the garage door incident that happened under the supervision of the very same supervisor who had been friends, if you will, with the first supervisor. After that, he's fine. He works, people appreciate his work. He's credited with safe driving records and awards, and he does fine. He's able to reapply to the program. He gets in the program, and lo and behold, he has 2 other supervisors who are, quote unquote, out to get him. There is evidence to say that one of the supervisors said that he was out to get him. That supervisor, as well as the first line supervisor, is one that, again, we believe was discriminating against him because of his color and because of his race, and engaged in retaliatory efforts. It becomes more complicated when you have the HR department or the LR department that apparently is responsible for advising the managers on the fact that he has filed, meaning my client, has filed complaints of discrimination with the EEOC and got a letter of probable cause in one of them. The last part, which you mentioned about the drive cam, was literally because he had informed the managers that he had filed yet his second EEO complaint. When he filed the second EEO complaint, he made them aware of that, including the HR department. From our perspective, lo and behold, now they've got someone who's coming forward and alleging that he is engaged in disconnecting his drive cam. Well, everyone's disconnecting their drive cam, but no one else is brought up for charges, only my client. And as a result of my client being brought up for charges at that time, he is now at the 5th level of disciplinary action, which ensures termination. All the other individuals were not brought up for charges until much later. Under the disciplinary process, under the progressive disciplinary process, your time is significant in terms of the length of time between any offenses. This is not a significant concern, obviously, for safety purposes. I am out of time, Your Honor.
All right. And Counsel, you've reserved quite a bit of time for rebuttal. Now, let me ask my colleagues if they have any questions. Judge Wynn, do you have some questions?
I do not, Judge Wilkerson. Thank you.
Judge Harris, do you have some questions?
No, thank you.
Okay. Well, we have no questions, and let's hear from Mr. Bisbee.
Thank you, Your Honor. Good morning, and may it please the court. Lincoln Bisbee for Appalese, Washington Gas Light Company, Dennis Samuel, and Kevin Gordon. Over the span of 5 years, appellant Kyle Dawson was disciplined 8 times by several different Washington Gas managers of different races. Mr. Dawson's position in this case is that he engaged in no wrongdoing on any occasion, and that each act of discipline was the result of intentional discrimination and/or retaliation. As summarized on page 2 of his reply brief, Mr. Dawson contends that multiple Washington Gas managers and human resources personnel, quote, perpetrated an unlawful systematic scheme over a series of years in order to terminate his employment. The record evidence does not support these claims, and the district court correctly entered summary judgment for Washington Gas and the individual defendants. Neither this court nor the district court is tasked with sitting as a super personnel department in determining whether a company's discipline of an employee was warranted. Under Title VII, it is axiomatic that a plaintiff must show that the stated reasons for his discipline were not the true reasons, but instead were a pretext for discrimination. When undergoing this analysis, it's not enough for a plaintiff to show that the company's articulated reason for discipline was false. The plaintiff must also prove that the employer engaged in intentional discrimination. Given the undisputed facts here, Mr. Dawson has not made that showing. Mr. Dawson's arguments incorrectly conflate.
Counsel.
Yes, Your Honor.
It's Judge Harris. Can you talk about the first 3 2013 actions against Mr. Dawson by Mr. Surdam? And you know, the context for these, right, is that we have these affidavits and interviews by Mr. Dawson's co-employees from the EEOC investigation, which do seem to substantiate the allegation that Mr. Surdam sort of has it in for Dawson, that he's targeting him, and that he's biased against biracial people. But the district court seems to have thought that was relevant only to the prima facie showing. And after that, they sort of drop out of the case. You don't look at it at the pretext stage. Is that how you read the district court opinion? And is that right? Or should we be looking at that kind of background context when we consider each of those, the pretext showing that was made as to each of these disciplinary actions?
I'm not sure that I would have phrased the test precisely the same way as the district court, but I do agree with the general framework that the district court adopted. And I think that proceeds in 2 parts. The first is that to establish pretext, the plaintiff must show both that the stated reasons were false and that the employer engaged in intentional discrimination. The question at summary judgment is, could a reasonable jury find both that the employer's explanation was false and also that the decision maker engaged in intentional discrimination? And why that's important the second point, I think the district court recognized that many of the arguments Mr. Dawson was advancing at summary judgment collapse his prima facie case with the ultimate showing at the pretext phase. That if it were simply enough to show that an individual of a different race were treated differently, that would make the same showing at the prima facie phase identical to the showing at the pretext phase. And that would turn McDonnell Douglas into a one-prong test, which would be counter to both this court's precedents and the Supreme Court's precedent. More specifically, with respect to the affidavits in the record, I would first note that the general idea that it was based on some sort of biracial status is largely, if not exclusively, based on hearsay, which is not admissible at the summary judgment stage. That the idea that someone heard the 2013 manager, Mr. Surdum, say, "Oh, I'm out to get so-and-so," would not be admissible evidence and cannot be looked at. Also, the evidence of alleged animosity towards biracial individuals were either conclusory statements such as, "I think he was out to get Mr. Dawson," or one instance where, when talking about dogs, Mr. Surdum said, "I don't like half-breeds." And I would put forth, Your Honor, that neither of those are sufficient to establish, as a plaintiff must, that there was intentional racial discrimination. Instead, the record evidence—
The district court did look at them. Excuse me, counsel?
Yes,
Sorry,
Your Honor, I apologize.
I'm obviously having trouble with my phone line. I apologize. I think it's on my end. The district court did look at these affidavits and interviews for making the prima facie case. Do you think that was wrong, that they should not have, the district court shouldn't have considered it? Because I thought there was some pretty specific stuff about ever since his, I don't want to repeat it, but ever since his daughter, I think, married a person of color, he's had this issue with biracial people. And the district court thought that was worth looking at, but you think not.
Yes, Your Honor. I think I have two responses to that. The first is, I think, as a holistic matter, I do disagree that those statements would constitute the kind of admissible evidence upon which a reasonable jury could find intentional discrimination. That the statements were, the daughter had been married, and as a result, he was biased against biracial people. Well, there were no specific instances of that bias put into the record other than the plaintiff's conclusory allegations. And then secondarily, the only specific example of an alleged comment relating to bias against biracial individuals was this comment about half-breeds, which again was made in the context of dogs. And the district court, at the end of the opinion in its analysis on the hostile work environment claim, I think accurately noted that these kinds of one-off statements were not enough to sustain a theory of race-based discrimination. And secondarily, as I noted a moment ago, these are also in large—
I'm just trying to figure out how we think about Mr. Surdum's disciplinary decisions, and given this background information we're getting from the co-employees. And maybe we could just focus on the step one tardiness reprimand, where you have the comparator evidence that Surdum did not discipline either the black or white employee for tardiness, and actually coach the white employee to avoid discipline by going around the back. Why isn't that enough to create a jury issue when you put it together with these affidavits and interviews about what was really going on there?
So what the district court concluded was that the mere showing that individuals of different races were treated differently is evidence at step one, the prima facie case, and that more is needed at step two. And the district court did not say this expressly, but the kind of evidence that one frequently sees at step two are a change in explanation, for example, which shows shifting rationale in pretext, or multiple overt racial statements. And that kind of evidence was not present here. And if the evidence in this record is sufficient, if sort of hearsay, conclusory statements from coworkers that just say, without giving specific examples, a supervisor is biased against one class of employees, if that coupled with alleged disparate treatment, that would allow any number of cases to pass muster, and the presidential opinions of this court and others suggest that that's simply not enough. I guess I would also say, even if it were the case that the initial step one discipline were racially motivated, it would not constitute an adverse action in the absence of a finding that some other piece of discipline issued by Mr. Surdum was also discriminatory. The district court's rationale for why the initial discipline constituted an adverse action was it became part of a causal chain. So even though a written warning is typically not enough, if it then results in additional discriminatory-based discipline, it becomes an adverse action. And I would say that for the other instances where Mr. Surdum was involved, the record is very clear they were non-discriminatory. So take the step 2 discipline as just one example. In that instance, there is really no dispute that Mr. Dawson was involved in an avoidable motor vehicle accident and that Mr. Surdum had nothing to do with that discipline. The safety department conducted an independent investigation that independently determined Mr. Dawson had caused an avoidable accident, and then the governing labor contract mandated discipline due to the number of points he had received. And so the follow-on disciplinary acts that create the chain the district court talked about, they are, in my view, plainly non-discriminatory, and it sounds like my friend Ms. Randall's not even challenging the step 2 discipline on appeal, or at least not at oral argument. If those fall away, it leaves the step 1 discipline as solely a written warning, which would be a non-adverse action. Again, we believe it to be non-discriminatory, but even if it were, it would still not pass muster.
In looking at a comparator, excuse me, Judge Harris, I'm sorry, go ahead.
I actually spent way too much time thinking about what happens if only one of these, this series of progressive disciplinary steps, if you only take out one. But you needed all 3 to get him thrown out of this program, right? So if one of them was impermissible, he would have not been thrown out of that program. Didn't you need 3? All 3 to get him tossed out of the program?
Causal chain where an intervening action comes into play. So it is true that Mr. Dawson needed all 3, but if the first discipline was allegedly discriminatory, and again, we believe it was not, but if it were, he was not thrown out of the program because of that discipline. He was thrown out because of the intervening event of a non-discriminatory violation with respect to, for example, causing an avoidable motor vehicle accident. That in any case, a written warning could always arguably have resulted in some impact down the road. A written warning impacts an employee's personnel file review or performance evaluation, and that impacts a raise, and the loss of money is an adverse action. That's not typically how this court or others views Title VII jurisprudence. Instead, once there's an intervening action, that sort of cuts off the chain of events causality.
This is something that we've been talking about a little bit in your dialogue with Judge Harris. But I want to approach it from the standpoint of comparatives. When you look at someone with a train of disciplinary infractions, what do we want? What is the relevant standard for a comparator? Is it a comparator with respect to each and every disciplinary infraction, or do we look for a comparator and saying, is there another employee with this entire train of disciplinary infractions that was treated differently? I mean, I think your discussion with Judge Harris has touched on this, but the question is, with comparators, do we go piece by piece and incident by incident, or do we take the employment record as a whole and ask whether someone with a comparably serious overall employment record was treated differently? What do you think our approach should be?
So let me start by saying, Your Honor, I think under either framework, the district court's judgment should be affirmed. And I can walk through both examples, however. I think if it were me writing a decision or me analyzing the district court's opinion, I would look holistically at all of the discipline, because I think that does weigh on the comparator issue and also weighs on whether there can be proof of intentional discrimination. I think it's interesting that my friend Ms. Randall in her opening remarks pivoted from the briefing, that no longer is there a challenge to all 8 of the disciplinary events, but now there appears to be a challenge to 4, which I think means 4 instances of discipline are now concededly not based on race, color, or protected activity. And where you have an employee who has repeated discipline from a manager, it suggests that that manager is not acting in general with racial animus or bias, but instead is acting for legitimate reasons. If it's undisputed, for example, that Mr. Surdum disciplined appropriately for one issue, it suggests he disciplined appropriately for other issues as well, and there was not bias. However—
Well, the reason I ask that is I think it's important because I think what employers are asking themselves when they make employment decisions, they're not so much going incident by incident, but they're asking overall, is this individual a good employee? Overall, is this somebody we want to keep with the company? And I think that is the way most businesses go about making those kinds of decisions. So when you say no, you want to look at this holistically, I do think that resonates and accords with what business reality is, which is that they want to keep strong employees on the job, and that they don't want to keep employees with repeated disciplinary infractions on the company. And so many separation talks when an employer talks to an employee about why that employee is being discharged, unless the singular incident is very serious, that conversation with someone who's about to be discharged will typically center on an accumulation of things. And the employer will be saying, well, you've been given multiple chances, and we've have tried to counsel you and the rest. And most employers act in exactly that fashion. And so what occurred to me is not any one particular incident, but the cumulative impact on them. And in searching for a comparator, I don't think it's illegitimate to look in terms of a comparator to somebody who had a similarly unfavorable tenure with the company. It seems to me unfair to ask a company to keep someone on with this level of infractions unless there are employees with different racial characteristics that are being treated in a different fashion. And so what I'm asking you is, if you do view this holistically, is there another individual that is likely a comparator who's been treated in a more forgiving or more lenient fashion than this individual was? The opposing counsel will also wish to address that. But assuming the holistic perspective, is there another comparator?
Yes, Your Honor. No, I'm not aware of any comparator that had 8 disciplinary events over the span of 5 years, or more granularly had 3 disciplinary events reporting to Mr. Surdum. And for what it's worth, my experience matches Your Honor's, in that I think employers oftentimes do, saying that even if one adopts the other view, however, I think the result stays the same. And I do want to briefly address that in case either Judge Wynn or Judge Harris views the event. It is true that both an African-American employee and a Caucasian employee did not receive a written warning for discipline, and Mr. Dawson did. And in the district court, I think correctly found that gets you past step 1 of McDonnell Douglas. The question then becomes, however, well, is there enough evidence, admissible evidence in the record from which a reasonable jury could find intentional discrimination? So it's not just that Mr. Sturdom didn't like Mr. Dawson for some other reason, but the driving force here is discrimination. And I would posit that there's not. And there are some sort of miscellaneous affidavits in the record, but those are extraordinarily conclusory, that they do kind of say, well, Mr. Sturdom was biased against individuals who are biracial, or they'll provide a alleged reason for his bias. But there are not examples of other individuals suffering discipline. There are not the kinds of specific examples that a jury would hear and be able to reach the conclusion that there was intentional discrimination.
But counsel wasn't, I thought, counsel, isn't it at least alleged, but I may be misremembering. I thought that Mr. Dawson was the only biracial individual on Mr. Sturdom's staff. So if you have people saying, if you have his co-employees saying he's picking on Mr. Dawson and he's biased against biracial people, I'm not sure what other evidence they could give you except that he's picked. What else would it? I guess what it seems like you would really require sort of a smoking gun admission. So if I heard him say he's picking on Mr. Dawson because he's biracial.
If I misspoke, I apologize, Your Honor. I certainly don't think that kind of smoking gun evidence is required. Something you see, for example, in other cases is a changing story that shows pretext or mendacity. I hear the bell. May I respond briefly?
You may finish your sentence.
Okay. That there's evidence of mendacity or specific examples of mistreatment elsewhere. A generic statement of disliking biracial employees becomes a perpetual loop where he's treating Mr. Dawson badly. Mr. Dawson is biracial. It must be because of biracial hostility. That's insufficient to establish a pretext under the McDonnell-Douglas test. Thank you, Your Honors.
Wait a minute, Judge Wynn or Judge Harris, do either one of you all have any further questions of Mr. Bisbee that you'd like to ask?
I just wanted to, just to get your thoughts in terms of it seems rather clear to me, but I wanted to check on it with you. Dawson argues that his failure to identify these comparators does not mean he's failed to satisfy his burden, and he points to our case of the Bryant versus Aiken Regional Medical Centers for the proposition that he can point to other acts which would be an inference for discrimination that can be drawn. Is the distinction there that was a promotion case and this is a discipline case? Is that the distinction that you glean from that?
I think that's at least one distinction, Your Honor, and the specific facts of that case are not coming to mind beyond that, and I apologize, but I do think it is a relevant and important point that when specific acts are shown, that is different than this case where there were just generalized allegations. And again, those generalized allegations stem from the treatment of Mr. Dawson. It appears that Mr. Dawson said in the workplace, I am being mistreated because I'm biracial. His colleagues seem to agree at times he was mistreated, though we dispute that certainly. And then they made the conclusory statement, it must be because he is biracial. And that is not enough to sustain a case at the third stage of the McDonnell-Douglas test.
And one other question, I just want to get your quick thoughts on it regarding the retaliation. Can a temporal proximity between a protected conduct and a sufficiently severe adverse action on its own be enough to prove a pretext in a retaliation claim?
Typically, no, Your Honor, for the same reason that would collapse the three-step framework of McDonnell-Douglas, that temporal proximity can be enough to establish it at step one. And if the identical is showing were required at step one and step three, there would be no need for steps 2 and 3 at all.
Thank you.
Thank you.
Judge Harris, do you have any questions you'd like to ask?
No, thank you.
All right, we would like to hear, Ms. Randall, you have some time for rebuttal, and we'd be happy to hear from you. Ms. Randall?
Ms. Randall, can you unmute yourself?
Thank you. I'm sorry. I'm here. Yes. I just wanted to clarify that the issue of comparators has been the case law for this court as well as the Supreme Court for years. Contrary to counsel's assertion that the courts have looked at a holistic appointment, it is truly the opposite. And it's because of the theory that discrimination is what I refer to as an attentional crime, if you will. It's the individual supervisor engaging in activity that's different because of the person's race. So you have to look at the supervisor, you have to look at the people under the supervisor. As a matter of fact, case law does say that it's sometimes difficult to identify a comparator, and you don't always need a comparator in order to prove a case. This court has said that in Cook versus CXT.
Randall, to that point, so are you saying you don't have the comparators here?
The issue for comparators is twofold. One, for purposes of establishing a prima facie case, and also the Supreme Court has said that it's also very important at the pretext stage. So you can.
Well, I certainly understand that, but let me ask you. I just want to be clear. I just want a clear answer in terms of discrimination enforcement of the employee disciplinary measures. Are you relying to any extent on having comparators? So you saying, yes, this is a case in which you don't need comparators, you have something else?
No, I'm not saying that, Judge. I'm saying, as a matter of fact, you can do both.
So who are your comparators? Who are your comparators?
For purposes of the reprimand, our comparators would be the individual.
How do you deal with the discrimination and the enforcement employee disciplinary measures? Who are your comparators?
It differs depending on the crime, if you will, and the supervisor. So the case law says they have to work for the same supervisor, be subject to the same standards, and for the most part, have engaged in the same behavior. So it has to be individualistic as opposed to holistic for purposes of discrimination.
But you are, when you're on appeal, I guess the case is Aikens, the McDonnell-Douglas proof scheme of, prima facie case, burden of production, question of pretextuality. Hasn't the Supreme Court also made clear that the McDonnell-Douglas proof scheme is primarily an instrument for ordering proof at the district court level, and that when you get to the Court of Appeals level, the question becomes much more of a holistic one and much more of an overall question that we are asking ourselves, looking at the record as a whole, is there a triable issue of fact on the ultimate issue of whether someone was dismissed because of race? And the Supreme Court in Aikens and other cases has said you don't on appeal look at the case in the same sort of step-by-step McDonnell-Douglas progression that you do at the district court level, that you look at it as an overall judgment based on the record in its entirety as to whether racial animus was the reason for the employment action here, a discharge that was taken.
Your Honor, I believe that for purposes of establishing whether a manager discriminated against an employee, you have to look at it individually. The issue of the use of comparators can be helpful. And if it is used, then that's where the requirement is. You look at the people who are under the same supervisor, doing the same work, and responsible for the same duties and responsibilities, because that can therefore add to the decision that it is intentional. If I'm treating someone that does the same thing I do, and the only difference is my color, then that gives not only an inference, but a potential finding of discrimination if you can show that the reason why I'm being treated differently is a pretext. The reason why he is being treated differently, we have established, is a pretext for purposes of the reprimand. We've established it's a pretext for purposes of the water.
Well, in a circumstantial case as opposed to a direct evidence case,
This is circumstantial.
are you saying you don't need comparators?
I'm saying that actually this court has said you can look at comparators. As a matter of fact, the appropriateness of comparators is usually a jury question. But there's always a difficulty in establishing.
Yes, but to get to a jury, you have to establish an issue of triable fact.
Well,
and you can't just say, well, when we get to the jury, we'll do this. But you've got to do certain things. You've got to do certain things at the summary judgment stage, and Celotex is very clear on that you got to establish an issue of triable fact under each of the Rule 56 requirements. One, there's got to be a genuine issue, and number two, it's got to be material. And it would just seem to me that comparators would be very important at the Rule 56 stage. Not you can't just say, well, we'll get to it when we get to a jury. You have to. You know, there's the initial Rule 56 requirement, and at Rule 56, all the inferences belong with you in terms of the fact that the non-prevailing party gets the benefit of all the inferences. But that has to be taken also in conjunction with the fact that it still is the burden to establish a burden of the non-moving party to establish a genuineness and materiality.
Yes, Judge, I'm out of time right now, but I did want to know if I could hit the other issues that have been raised, and that would be whether, in fact, you have one person who is biracial. You actually have two people not in the same career, and that's again the reason for it. But he also gave testimony that says, I was treated differently. I was treated badly because I'm biracial. So there are additional statements that have been made to support the concept that he was discriminated against because of his biracial status. We also have the issue that has been identified about throughout the 10 years of his employment. He's been employed for 12 years, Judge. And the fact is that he has had the ability to get into this program because of his good background and good work record, as well as disciplinary record. There's a requirement that you have to meet, which is not serious disciplinary actions in order to get into the program. He's gotten into the program twice over the 12 years and succeeded the second time. So it's not as though you have someone who has been, has been insinuated, a terrible person for 12 years. He hasn't been, quite the opposite. He's only been, quote unquote, a terrible person under the supervision of the individuals that have been alleged to be discriminated.
All right, thank you very much. We appreciate it, Ms. Randall. And I'm going to ask both Judge Wynn and Judge Harris if they have any further questions of you, and if they do, we'll let you answer those.
Thank
Judge
you,
Wynn?
Wilkerson. I do not have anything further, Judge.
Judge Harris?
No, thanks.
All right, sorry we can't come down and greet you, but I want to thank both of you for your advocacy this morning and the help that you provided to the court. So many thanks to you both. And what we'll do at this point is take a 5-minute recess and come back and hear our final case.
Thank you, Your Honor.
Thank you, Your Honor.
The court will take a brief recess before hearing the next case.
I'll move all the attorneys into the waiting room.
Thank you, Your Honors. May it please the court. My name is Charles Cochran, and I represent Marion Campbell. And at the trial of Marion Campbell, 3 pieces of evidence were introduced against him, which unfairly prejudiced the jury. The pieces of evidence were 2 recorded jail phone calls, which took place 9 months after his arrest with an ex-girlfriend, in which the ex-girlfriend discussed with Mr. Campbell her future plans to sell drugs and to potentially manufacture drugs. These 2 phone calls were then bolstered by an expert who was introduced by the government to tell the jury about what the 2 were talking about in terms of their drug lingo. The person that Mr. Campbell was talking about was named Lee Guess. She was an ex-girlfriend. She was not in jail, and she was discussing with Mr. Campbell the fact that she wanted to procure meth to sell, and Mr. Campbell then engaged in this discussion with her. Mr. Campbell was charged with possessing drugs with the intent to distribute and possessing a firearm in a car. The conversations, or the subject matter of the conversations that he was having with Ms. Guess, were in no way related to that day when he was arrested. And they did not go in any way to prove that he knew that the guns, or that the gun or the drugs were in the car that night.
Well, that's a fair point. Why doesn't that go to weight rather than admissibility? I mean, when you said that the conversations did not relate to that particular day or to the particular charge, isn't that just a question of weight? Well, it's a fair point you make, and it's certainly a good point to bring before a jury, but I don't understand. It just seems to me a question of relevance and weight. Why is it anything? Why is that a question? How is that a question of admissibility?
Well, Your Honor, and thank you, Judge Wilkinson. The way that I would respond to that would be to look at the arguments and the opinion in this court's holding in Hall, which was also a prior bad act case and thoroughly reviewed an issue very similar to this. The court ruled in that case that the bad acts were not admissible, and that primarily because the issue at trial in Hall and in our case is whether or not the defendant knew or had dominion and control over the illegal items. And the issue had not been raised.
Ask you this: one of the in the Hall case, I think that the convictions that were at issue had occurred more than a half decade before, and here it was represented to me that the calls here occurred 9 months after the defendant's arrest. So there's a difference in the time span there. And the other difference that the government points out is that these were the defendant's own statements and his own words, and he was the only one in the car where the drugs and the weapons were found. And in Hall, the actual ownership of the drugs was very questionable. So you have 2 possible points of distinction under 404B with Hall, and why wasn't it within the discretion of Judge Hendricks to admit that evidence as related to knowledge and intent, which the defendant had to be denying in a case like this, and to just let the jury assess the weight of it all?
Well, Your Honor, I believe that the issue we have to come down to eventually is whether or not it was unduly prejudicial. And this is a phone conversation in which Mr. Campbell is purportedly discussing with somebody her manufacturing of drugs, and the potential for prejudice there for the jury to take that and say, look, he's talking about this 9 months later, and he must be the type of person who would know if there were drugs in his car or a gun in his car. But they were not relevant to his knowledge. And in that sense, these pieces of evidence are putting the cart before the horse in trying to prove knowledge and intent when they haven't proved the dominion and control, the actual knowledge that those things are his, whether or not he's guilty of possessing them at all.
Mr. Cochran,
Yes,
I think you could spend your time on talking about Rule 404B, and we could probably have a very lively conversation going back and forth. But my view of it, at least my perspective, and I don't know what my colleagues feel about it, but it looks to me that evidence meets the 404B. I mean, it's relevant to his knowledge of his intent to sell it. It's necessary to prove the elements. If the calls are reliable, the probative value of it is there. There's no unfair prejudice. Yeah, I think, at least from my perspective, more interesting issue in this case deals with whether there was an abuse of discretion by admitting the testimony of the Special Agent Briggs. And I'll take it there just so we'll be pointed in terms of it. I don't think that's an issue of whether he's an expert. You seem to come out very candidly and say he is an expert. I mean, on our case law, at least for that purposes, I mean, it could be challenged on so many ways because judges have become pretty lax in terms of what they call an expert when it comes to narcotics case. I mean, but we'll take it, he's an expert. The question then becomes, when we look at Wilson and the other cases that there, did his testimony include the sufficient indicia of his methodology as it was applied in that instance? In other words, it's one thing for him to be an expert and then say, well, I have the experience, I've been surveilling these calls, there's no evidence I see here that he's been an undercover agent of any sort, but just that he's been around the drugs, he knows the talk, the lingo, the codes. But the question then becomes, once he begins to say, okay, this term means that, is that enough just that he has the experience, or from your perspective, speak to the question, I think, on whether the reliability testimony is there as to why we should believe this expert that term means that in this case.
Your Honor, I appreciate that point, and we agree that Agent Briggs was a very experienced law enforcement agent with drugs in particular. However, he did not provide testimony as to why the methods he was applying to this case were reliable. He was listening to a phone call. He had never spoken to Mr. Campbell. He had never spoken to the woman who was on the call with Mr. Campbell. He had simply listened.
Why is his experience not just enough? I mean, he's been around drug folks. He's been hearing conversations, I guess like anybody else. Why is that not sufficient from a 702 perspective, or just in terms of an expert opinion testimony, is that not necessary here? We require, of course, in scientific cases, other cases, is it not different?
Your Honor, well, we would argue that that what his testimony is part of the problem, what we were concerned with his testimony was the subject matter of his testimony. Obviously, we've appealed the admissibility of the calls. Those calls are what he was testifying about, the content of those calls. He did not tell us why he was an expert in the particular case that was in front of him. He knew a lot about drugs. He knew a lot about the manufacturing of drugs, and he knew a lot about pricing of drugs. The problem is—
Well, why didn't you go after that on cross-examination? I don't have a problem with the points you're making, but we're taking so much away from district courts by trying to make these questions of admissibility. And if you say, well, this was the problem with the expert is he hasn't said, you just say to the jury, this expert hasn't said, hasn't told us why he's an expert in this kind of drug, why he's qualified to talk about this. He hasn't told us how this relates to the particular conversation at issue, or it doesn't relate to the particular charge at issue, or it doesn't relate to the particular drug. And you can make those points, and then the government can come back and say, well, here's what he knows, and here's why it is. Here's why it's deserving of your consideration, and here's why it is relevant, and here's why it is weighty. And you can say, no, it's not for reasons A, B, and C. So what is it that you want done?
Well, what we want is that our problem with Agent Briggs's testimony was that he was testifying with regards to the content of these calls. In the context, a lot of it was about how you make meth and how meth is brought into the United States in the global drug trade. This was a car stop. Our case was an auto stop where the issue was whether or not the defendant knew the illegal items were in the car. We did not need an expert to sort of come in and impose his authority on the jury and tell us what these phone calls were about and really emphasize the prejudicial value of these phone calls. And I would push back on the point that Judge Wynn made with regard to the relevance and necessity. These were not necessary calls to demonstrate intent to distribute. There were baggies in the car. There was testimony as to the way they were packaged. And it was not relevant at all to why Mr. Campbell would have known that the drugs and the gun were in the car unless they're being used to say, look, he knows about drugs. He must be the kind of person who knew that this stuff was in the car. And that's the problem that we have when you take the calls and the expert together. It creates an enormously prejudicial situation for Mr. Campbell. And I would also point out that, yes, the time difference in Hall was much different than it is here. But if you look at McBride, you've got an 18-month difference, where the court is also pointing out the differences between the prior bad act and the case at hand. You know, it's 18 months. It's a recorded conversation. Yes, Your Honor.
Yes, this is Judge Harris. I had a question about the time. We've been talking as though the relevant lapse of time is 9 months. But it sounds like from the conversation, the defendant, your client, is talking about something that happened in the past, right? Like, this is how much I was paying. These are people to whom I did sell meth in the past. And most likely, you know, probably in the recent past, because that's what would make it relevant, these prices and these people who have purchased drugs. So anyway, my point is the relevant space of time, right, isn't between the call and the arrest. It's between the things that the defendant is describing on the calls and the arrest. And that's going to be less than 9 months, right? Because he's talking about things that happened before he was put in prison. And that was 3 months ago, I believe.
Yeah, yes, Judge Harrison, thank you for that. It was 9 months between the arrest and the phone call. I'm sorry. What I'm saying, right? Yes. And I'm afraid I'm not making myself clear. And Mr. Campbell admittedly does make a reference to the past where he references, this is what I've been getting it for, referencing, you know, the price that he obtained drugs for in the past. The problem with that is that he's got numerous drug convictions for different substances, the same substance. And the other issue is that much more of the call is about Miss Guess and her future plans to obtain, make, and sell drugs. And Mr. Campbell being engaged in that completely irrelevant conversation is highly prejudicial. The reference to the past is really that one line where he says, you know what I've been getting it for. And that could be referring to prior convictions, which obviously the defense would not want to use that as a counter argument to the jury. It also could be referring to after Mr. Campbell was arrested in this case, he bonded out. He only had state charges. He bonded out and was again pulled over by the police more contemporaneously with this, in a separate case, more contemporaneously with the phone call. So the problem is that we have these available arguments to us, which we can, you know, make candidly to this court, but we wouldn't want to be sandbagged into bringing in further prejudicial evidence or further bad act evidence against our own client to counter the relevance of this particular call. And so what we have now, I think, is a sort of a hybrid of a factual situation where you have in Hall and that you have in McBride, where you've got the defendant's own words being used against him in a relatively extensive period of time since his arrest that's not specifically referring to the actual criminal conduct that he's been arrested for, that he's on trial for. And this court should find, as it did in McBride and as it did in Hall, that this was because this was evidence that was going to prove intent and knowledge, but the government did not have the ability to overcome that mere presence argument from the defense. I see I'm running out of time here. This court should follow the rulings in McBride and Hall. Thank you.
How was this a mere presence thing? I mean, I thought that he was the only one in the car where the drugs and the weapons were found.
Well, Your Honor, he didn't.
How is this a mere presence case?
Because he's merely present in the car. There is no fingerprints on the items. There's no DNA on the items. There's no admission from the defendant that he knew about the items. And that's exactly the case that you had in Hall, where the defendant admitted.
Well, isn't that a jury argument?
Well, we did make the argument that there was no fingerprint evidence, no DNA evidence. The problem is that the government didn't have proof or evidence to specifically address that mere presence argument. You've got a guy who's in a car that's got a smoking engine with radiator fluid burning. There's bottles of radiator fluid. But what happened here is the government sees that they've got a problem with this mere presence argument that he could make, that he's just there in the car to fix the car. It's not his car. And they listen to these jail phone calls and they say, hey, look, this is him talking about drugs. We can use this to prove knowledge and intent. When in fact, it's really bootstrapping along to try to prove that he knew. It's using his character to say that he knew that these items were in the car.
Okay, thank you, Mr. Cochran. And I want to ask my colleagues again if they have any further questions. Judge Wynn or Judge Harris, do you all have any further questions?
I just wanted to point out to you that when you come back, I want you to focus more specifically on the things I tried to point you to. And that is the question that deals here with when an expert of a drug expert testifies. The question begins, if he makes this statement, does he have to add to it testimony to establish the reliability of the method that he used to determine whether it's true or not? That was required in the Wilson case, even though they found harmless error in the case. And the mere fact that he states it to be, this word means this. If you just go back to experience alone, that's one way you could look at it. But I do believe, from my perspective, you have to have testimony pointing to the reliability of how we going to believe this expert's use of this data that he's gotten is what it is. So focus that, if you will, when you return for your rebuttal.
Yes, Your Honor. Thank you.
All right. Judge Harris, did you have any further questions of Mr. Cochran?
No, thanks.
Okay. Then we'll hear from Ms. Henderson. Ms. Henderson, do you want to give us your view of the matter?
Yes, Your Honor. Good afternoon. May it please the court. My name is Kara Henderson. I represent the United States on this matter. The record shows the district court conducted a thorough and exacting review of the jail phone call evidence in this case, and therefore did not commit an abuse of discretion in admitting calls 8 and 11 into evidence. Pursuant to Rule 404B, the statements made by Mr. Campbell in both calls were relevant to show his knowledge and intent to distribute the meth found in the vehicle with him. By claiming mere presence, Mr. Campbell placed his knowledge and intent at issue in the trial, thereby making his statements in both phone calls probative of more than one contested element of the charged offense. Because the admitted evidence was Mr. Campbell's own recorded statements regarding distribution of the same drug he was charged with at trial, the evidence was both reliable and more probative than prejudicial, and the district court's ruling should be affirmed. Over a month prior to trial, the government filed
Counsel, well,
yes, Your Honor.
Counsel, this is Judge Harris. Can I ask you just a quick question?
Yes, Your Honor.
It looked like before the district court, you argued that 404B didn't apply at all because this evidence is intrinsic. Is that an argument you're advancing on appeal, or is the only argument in front of us that it's permissible under 404B? Your
Honor, we did argue before the district court that these other acts were more intrinsic than they were admittable under 404B, because he was discussing on the phone call what he had been paying for his meth, the quality of his meth, and his plans to continue the distribution of his meth once released. So we did argue that it was all part of a single criminal episode of his meth distribution. However, because the district court admitted the evidence pursuant to Rule 404B to show knowledge and intent, that's where we focused our argument. But we do still believe that they are part of a complete single criminal episode.
Well, how would it be intrinsic if they weren't the same? It certainly wasn't the same exact drugs. It was in the car. I guess I see this as more of a 404B question than an intrinsic question. I mean, if you rule everything like this to be intrinsic, there's a danger of just ruling out the 404B evidence altogether. You know, any past involvement with drugs, we'll just call it intrinsic, and that could, you can pour in a lot of character evidence onto the grounds that it's intrinsic. I mean, there's a definite place for intrinsic evidence, but I have a problem with saying that every past involvement with drugs on someone's part, even if it's not related to the exact transaction or whatever, is intrinsic. It seems to me you're making an awfully broad argument. The implications of that argument seem to me to be very broad. You see what I'm saying? You see my concern about it?
Yes, Your Honor. And that's why we made the argument, but we also respected the district court's decision to disagree with us, but then to admit the evidence pursuant to Rule 404B to show knowledge and intent. So as I stated in response to Judge Harris, that's why we focused our argument on 404B in response to this appeal and did not touch back to the argument that it was all part of a single criminal episode. But Judge Harris was correct. We did make that argument to the district court. So, Your Honors, as I was saying, a month prior to trial, the government filed its notice of intent to introduce the evidence pursuant to Rule 404B of the recorded jail phone calls. And obviously several phone calls were admitted, but only 8 and 11 are at issue here. So looking at their admissibility individually and starting with call number 8, Mr. Campbell's statements on this call indicate that he was purchasing meth in the summer of 2017, which was the time of the arrest in the instant case, and he planned to continue that meth distribution upon release. In line with the court's decision in United States versus Hodge and the Sixth Circuit decision in United States versus Barnes, these statements show the existence of Mr. Campbell's continuing narcotics business and therefore are probative to show his knowledge of the drug trade and his intent to distribute the meth found in the vehicle with him. When you look at call number 11, Mr. Campbell's statements on this call showed that he did not just possess meth for his own use, but that he actually distributed meth to customers. And case law shows that using other acts pursuant to Rule 404B to show specific intent in certain circumstances is most frequently admissible in cases involving possession with intent to distribute, making Mr. Campbell's statements on this call highly probative and relevant to show his intent to distribute the meth found in the vehicle with him the night of his arrest. The evidence in this case, Your Honors, shows that the statements that were made by Mr. Campbell on these phone calls, again, were about distributing methamphetamine, conduct that is clearly substantially similar to the charged conduct of possession with the intent to distribute meth.
In addition to the 404B evidence, what other evidence did you have? What was the other evidence that was brought in against Mr. Campbell?
To show in general, Your Honor, or to show knowledge and intent?
No, the other evidence with respect to the counts with which he was charged.
Your Honor, yes, Your Honor, the government presented.
I'm talking about the possession with intent to distribute the drugs. I'm not necessarily talking about the possession of the firearm. I'm talking about the possession with intent count.
Yes, Your Honor. The government presented that Mr. Campbell was the driver and only occupant of the vehicle. Everything was within arm's reach of Mr. Campbell. Therefore, he had the ability to exercise dominion and control over it. One of the plastic bags containing the smaller bags of meth was sitting in the driver's side door. There were 2 jail phone calls, jail call number 1 and number 4, that I think goes to knowledge, but both of these go to knowledge, where Mr. Campbell is trying to, in jail call number 1, Mr. Campbell is talking to his girlfriend and he's telling her that she needs to get someone to come take the gun charge. And she tells him, but you know what, while you're in there, think about this, no more. And Mr. Campbell responded, nope, no more, you're right, I gotta stop, no more bullshit. I apologize for the expletive, but I wanna get his words right. In jail call number 4, very similarly, he's talking to his mother about getting money from someone to pay someone else to come claim the gun. And he tells his mother, but Ma, I can't, it's time for the bullshit to stop. I ain't gonna be doing no more, none bullshit, no more, because I'm gonna have money, I'm gonna have that money. Which the government argued were also admissions as to his knowledge as to everything in the vehicle. Additionally, Your Honor, all the other phone calls that showed Mr. Campbell was trying to bribe a witness to come in and claim the gun, and the various stories that he was trying to come up with for those witnesses to tell, go to not only prove his guilt as to the knowledge in the gun, but also we would argue that it shows knowledge of the drug, because he's not going to get someone to come in and claim over 36 grams of meth. But he can get someone who's not a felon to come in and claim the gun, and because that wouldn't be a crime. And then he knows he can separate the gun from the drugs, or at least attempt to. Additionally, Your Honor, the evidence of distribution, the way the drugs were packaged, there were 41 individual bags packaged in different weights. And Agent Briggs' testimony about the quantities that meth is distributed in for users and how the individual bags of meth in this particular case were packaged in those same quantities. The street value, and then the testimony from the other officers, the state officers, how there were additional plastic baggies, the $20 bill that was sitting on top of the meth in the center console that the defendant, Mr. Campbell, signed for in his property at the jail. So, Your Honor, those are a few of the other things that the other evidence that was put in to show Mr. Campbell's knowledge and intent to distribute the meth in the car.
All right, thank you. Do you have any comment on the admission of the DEA agent testimony?
Yes, Your Honor.
And let me guide you at least to what I think is relevant there, so we can focus on it from that perspective, because I'd like to hear your take on it. You know, when you go back and look at the Wilson case made it clear that this is an expert. That's not a contest here. But the problem, at least in Wilson points it out. It says, well, these principles, you got a person that's expert and he can testify, but he's got to testify that it's reliable and applied reliably to the facts. And even in Wilson, it says not everything that was in that court was met that standard. But what Wilson says, the defendant didn't object to it, so therefore it applied a plain error type review to it. So in this instance where we have, and by the way, the Wilson points out that it cites a case that the primary purpose of the coded drug language is to conceal the meaning of the conversation from outsiders. Now, I know that's been stated in many cases, and it's out there as though it is fact somewhere, but it can't be much of a conceal if here you have an agent who there's no evidence he's been an undercover agent or whatever, but at least from my perspective, the purpose of coded language is to provide precise conversation between the people who are speaking so that you know exactly what you're doing, because the risk of not doing it right is pretty high. These people will kill you. They'll do all kinds of stuff. So I mean, that's a court thing, but I'll leave that alone in terms of what the purpose of this language is. And if it's so concealed, it's amazing all the police officers know this language. And it's not just the expert here. But the issue that I have with this, it has to do with the testimony that he rendered at trial. Is it supportable for reliability purposes and in terms of satisfying the methodology of just saying he has the experience. Is that enough?
So, Your Honor, what I think we have to look at here is that it's not just that he's saying, I have experience and that's enough. So, but he does, when he goes through his experience, it's very detailed as to what exactly his experience is in. And I would point the court to the fact that 10 out of his 20 years in the DEA were spent solely on methamphetamine.
See, I want to make sure we focus this. This is where I want to make sure we're in agreement. I agree with you. I'm not challenging his expertise method. He has experience. He has a lot of experience. What we don't have is why it is that now we have this data. Why did he find it to be reliable? In other words, this is not a peer review sort of thing where it's a personal expert thing. He has been doing this surveillance and he has been doing this over the years. He has seen this. And there's no testimony that ties in when you say something is clear. How do you know that? Well, because I heard it such and such a time, this number of times. No, what we got is experience, which gives him carte blanche opportunity to classify anything as lingo. It's a judicial laxity that we have undertaken that continues. And it's part of the problem we're dealing with when we're dealing with police testimony. We have standards that they should be held to. It's not just the semantics here. We're dealing with real stuff. So that's what I'm getting at, is where is that testimony? Yeah, I accept he can say those things, but he has to add some testimony to it to say why it is reliable.
Yes, Your Honor. I understand what you're trying to get me to focus on. And I would say that the Rule 702 Advisory Committee specifically addresses Your Honor's concern in that it specifically states that the type of expert testimony, this type of expert testimony by agents who are qualified as experts in drug trafficking to decipher code language used in the drug business identifies that the method used by the agent is the application of extensive experience to analyze the meaning. The court in United States versus Smith most recently, Your Honor, reiterated the advisory committee's note.
I have no doubt that the courts and judges have gone in this direction, but I think that we have to be some level of understanding here. And that is what you're basically saying is once he gives his experience and all this, he can say what he wants to say. And it's all, understand, again, it is particular to him. He's an expert because of that. There's no there's no testimony about his expertise or he's recognized in journals or that sort of stuff. You got court cases where he's been recognized as expert, but that's just piling on. That's just saying we found from the beginning he's an expert. We have to maintain some means of discerning objectively that this is a reliable method. And it can't be, I've been hanging around drug folks and doing surveillance of them, and I've been through training and studying them for years and years, and now I know this because I know it, based upon my experience. And if we're there, we're just there. But I don't think that we're there. I mean, perhaps the best experts in terms of drug culture are probably in the prisons or the drug dealers themselves. But here we are dealing with specific lingo. Now, in this instance, I mean, there are particular words here, and the question of whether or not there were proper objections in this manner is a question that remains out there. But in terms of articulating his method and why this court should accept this expert's testimony of an opinion as being reliable, I think is missing.
Your Honor, what I would argue is that their expertise, and I know you're going to feel like I'm repeating myself, but if you'll give me a little leeway, his expertise.
If you're going with the experience thing, I got you. If you want to believe experience does it alone and that's good enough, oh yeah, you're right. The courts have exactly agreed with you on that. Just because he is experienced, he's done this over and over, and we just know he does it because he does it, that's not good enough for a legal determination that can be objectively applied. And that's the problem we got in dealing with police testimony is judicial laxity of rules there. They can follow the rules, but if we keep doing where we're going now, pretty soon he'll get up there and just say, I've been doing this for a while, judge, just let me just testify. And that's pretty much what's happening.
Well, one of the things I might point out here, I think I'm correct in this, is during his DEA service, it wasn't just that he was generally familiar with drugs, but he'd spent 10 years in Iowa working almost exclusively in methamphetamine cases, and he'd worked in methamphetamine cases in South Carolina, where he relocated, but it wasn't just general experience. It was experience in working with methamphetamine cases in particular. And as I understand it, the experience that he had both at the academy, it wasn't just street level experience either. It was experience at the academy, and it was experience from interviewing over hundreds of drug traffickers and listening to hundreds of hours of surveillance. So it's not just disembodied experience, it's very relevant experience. And I think Judge Wynn is right in saying that our cases have validated this, as well as the advisory rules. And there seemed to me that the real question that Daubert was concerned about was putting on quack science, particularly in cases involving scientific or specialized knowledge. What you're worried about is imposters and people who are almost fraudulently holding themselves out as experts with materials that have not been peer reviewed or anything of the like. But we don't have that kind of problem here. We have evidence admitted under abuse of discretion standards, and we have the court precedents, but mainly we have somebody who simply could not have more experience, both academic and street level experience, and not just with the drug trade in general, but with methamphetamine in particular. So it's hard to see how how admitting that would be an abuse of discretion. And maybe you have something more to add to that, M.S. Henderson. That was just my. Maybe you have something more to add that I've overlooked. Have I?
Your Honor,
Judge, I want to add to what you've said in her discussion, so that we are clear. I'm not disagreeing with you that he's an expert. I'm not disagreeing that in Iowa he knew about meth. He's in South Carolina, by the way, and there are presumptions and assumptions that courts make and premises that you accept. First, that drug culture is the same across this entire United States. That those who speak in this so-called code language is the same here. That he is an expert. Once we get him there, and I don't care where he's been or how long it's been, he now can get up on the stand and say anything means something. I'm simply saying that in Wilson, it was error for an officer not to provide any reliable explanation as to why he opined that the conversation meant what it said. I'm okay with him saying it happened. As you've just said, he's an expert. He's been around meth. He's got all of this. Here's the laxity in the courts and where we are failing as judges, in my opinion, where we're failing. And this is how you end up with individuals who then themselves do not adhere to the stringent requirements, which are not that hard. And it's simply just to say, yes, you can testify here, but you have to tell us, the court, how is it that you know that term means that? We're not just going to accept that you know, that you can say as a conclusory way. And it may sound like it's foregone, but those kinds of conclusory statements in a way is, well, everybody kind of knows it and it's all common sense. He spent some time in Iowa, he trained and he's been around this, and now, let him testify. And when they do, they testify with impunity to the point that they defy case law. I think what's required under 72, yes, you can testify. We already given the leeway to testify based upon the fact of his experience, but he has to explain to the court, okay, we accept your opinion that that this means clear. How do you know that? That's a simple thing. And then he tells us how he knows it. We need to put the government through these paces because 702 and Wilson requires it. So I add that to Judge Wilkinson's comments so that we make sure that we are on the same page. Most of what he's saying, I absolutely agree with. I mean, we're going to talk about Iowa and what he does and the training of the Marine Corps, the whole bit. That's wonderful. But it does not, he's now in court and he's now being recognized as an expert. He's now given an opinion. All we're asking is, where is the testimony that says when you give this opinion, we now can rely on it? What is your method that you use to determine that, officer?
And I realize that I'm out of time. If I may be able to respond, Judge Wynn, to your concerns briefly. I would say that, you know, Judge Richardson, in his opinion in Smith, addressed Your Honor's very concern in that it's impossible to ask these experts to lay that precise of a foundation like a DNA expert or a latent print examiner expert could based on experiments and other things, because their expertise was gained over extended, repeated exposure. And you can't, it's not just one moment in one time that said clear means this because this. I think what we have to look at is that when he detailed his experience for the jury and laid out, you know, all of his experience and why and the things that he knows about meth, and then applied his training and experience that he had just laid out to the questions about the evidence, and then was subject to cross on these questions.
Let me just say, because I think we could cut it short by if I get you to acknowledge this point. Basically, you're telling me we simply accept what he says because of his experience and he knows what he's talking about, and we are just going to have to take it. We don't get to go and know how it is that he knows this. We don't get to know why it's reliable because it's reliable because it is his experience, and that's it. Is that what that sounds like the essence of where we are? He knows what he's talking about, and when he walks into court, once we qualify the expert, we're not going to go and ask him, how do you know that term means this?
Your Honor, I think your concern goes more to weight than admissibility. I think that's a jury question. I think it's up to the jury to determine.
Oh no, you're the one that before trial came and said his testimony is like that of an anthropologist. You said that, and there's no explanation whatsoever that methodology. The prosecutor came up and said, "Oh, his testimony is like that of an anthropologist." That requires methodology. That's not a weight deal. That's admissibility.
No, I understand, Your Honor, but I'm saying I think that when they use their experience, which is what is all that they are able to use in this situation, that is the method that they use, as we've discussed at length here, is the method is their experience. My point was that when they are using that experience to then justify their opinions as to the evidence, I think that it's a jury question as to whether or not that they believe the experience and they believe that experience gives them the credibility to make that determination. There's no way. I think I'm
satisfied where I think we're just at an impasse on this, and I understand the use of experience and the jury get to weigh the experience and all of that, but he's an expert. So his experience is really not in question here. We've got that. He is an expert. He gives a statement. All I'm saying is when he gives that statement, he needs to tell us how does he know that's true. He needs to give us why it's reliable. He's got to tell us something beyond, well, this term here, if it could pick a term out of midair that we have no idea. The leaf was shipped to the store, and he tells us that means that a certain amount of cocaine was shipped somewhere. And
well, that would have been a great.
There, and we say absolutely nothing, and then you know he doesn't explain how he knows leaf being shipped to a store means this or that. Other than, well, in my experience, I just know through experience, and that's it, Your Honor, and you're not going to get into more because it's hard for me to figure out.
There has to be a role for cross-examination here, and all of the points my good colleague makes are points that can be raised. And in cross-examination, but I do think that the court's precedents and the federal rules and the district court's discretion make it an admissible case. There's admissible evidence, and the problems that Daubert identified with expert evidence don't seem to me to be particularly present in this kind of situation. But at any rate, do you have anything further, Ms. Henderson?
Well, Judge, I want to comment on that. I want to make sure we understand. Excuse me, I'm speaking. Judge Wilkerson made a comment. I want to give him the respect of commenting on it. I don't want to harbor thoughts, Judge Wilkerson, that we don't discuss, because we're very good at that, and I think this helps the jurisprudence. I think when we are dealing with cases of this sort, and the whole question of whether evidence like this is admitted or not, it is a question of the court's methods and the ways in which we do it. And courts have a way of accepting premises and moving forward with things without really questioning them once they've been said. I understand the value of precedent, but in the underlying situation of an expert witnesses, and I think if I have to go further with this, and I do believe it goes there, this is part of the underlying problem we confront in this country today. And that is, we have courts who do not adhere to the textualists or to the actual strict nature of what our role is as courts. And if we adhere to these things and do it, it's amazing to me, throughout my tenure as a judge, which has been over 30 years, it is amazing to me how we conform. That's true with Miranda. That's true with, the Miranda warnings. I mean, once you set standards, they are conformed with. They become a way in which you do things, and it helps us in terms of making sure courts don't make mistakes and we don't admit testimony that's not good testimony. I'm not saying this is not good here. This is not a good case in terms of this. I mean, this is bad evidence here. I agree with you on that. I think government had a particularly strong case here. I'm simply saying in terms of adhering to that is required and the other things. So we're not disagreeing, Judge Wilkerson, in terms of the importance of it. We're not disagreeing in terms of the expert. Of what we perhaps are disagreeing with is in terms of what an expert testimony means in this instance, and the need for the witness to explain the method and the reason it's reliable. That's where I think you and I differ a bit on, but that's sometimes judges just have to disagree.
All right, thank you very much, Ms. Henderson. And Judge Harris, would you like to ask some questions of Ms. Henderson? Do you have anything you wish to ask her?
I did have some questions. I need to keep everybody. Is it all right if I ask just a couple of questions? Judge Wilkinson.
All right. I don't want to cut anybody off here, so let Mr. Cochran, you reserve some time for rebuttal, so we'd be happy to hear from you again.
Thank you, Honor. May it please the court. Just to add to this discussion on the expert witness and the cross-examination that did take place at trial, Your Honor. One thing I would want to point out are a few examples of why Judge Wynn is right to be concerned here in the fact that there is no methodology or reliable methodology cited by the expert. And that is, first, the language that he talks about, the drug lingo, that was inconsistent with his testimony, which is he admitted on the stand that shake was something that was referred to during these phone conversations, and that shake commonly refers to marijuana, not meth. He talks about purity, but again, we had other phone conversations that were excluded about heroin, and certainly purity could refer to any kind of drug. He also
what did you bring up in cross-examination?
I'm sorry?
When you cross-examined Agent Briggs, what did you bring up? How did you go about your cross-examination?
Well, Your Honor, we did focus on the confusing nature of one of these calls where the word shake was used, because he was particularly testifying about the coded language. And he admitted on the stand that shake refers to marijuana, not meth. He also talked about ammonia. and we cross-examined him on the fact that Mr. Campbell was saying on this phone call that—
And this was all in your cross-examination of Agent Briggs?
Yes, Your Honor, and where he was about the phone call where Mr. Campbell asked or instructed the other person on the phone to pick up ammonia at a hardware store, pure ammonia for making meth, Mr. Briggs said. But under cross-examination, he admitted you can't get this type of ammonia at a hardware store. So the problem is that we can bring out those inconsistencies on cross-examination, but at the end of the day, you've got this very authoritative figure who's gone on for 30 minutes about his credentials, who is telling the jury, look, this guy's talking about drugs. This is how bad the global drug trade is. This guy's definitely talking about it. And then you transfer that to the calls, which are unrelated to the actual night in question. And the problem here is that we don't have that connection between the calls and the incident where Mr. Campbell was arrested. He's not referring to, oh, those drugs I had in the car that night, or the gun I had in the car that night. He's talking about the past in general in one sentence. The rest of these calls are about misguess.
Well, you know, the problem, there's another problem here, and that is that you can easily push experts and say, well, you know, talk about the particular situation here, talk about the particular situation here, and then you can push them in the direction of being a 701 fact witness. And you can also push them in the direction of sort of opining on the on an ultimate issue of fact, which they're not supposed to do. And so you can the expert is supposed to, part of it is supposed to testify generally. And if you push in the direction of particularity, you run into, you can take the expert, and then the assignment of error on appeal will be, well, he was supposed to be an expert, and he eventually ended up being a fact witness and opining on the ultimate issue of knowledge and intent.
And I agree with that, Your Honor. I think that the problem is that the subject matter of his expertise was in listening to these calls and interpreting them for the jury. And what we're arguing is that those calls did not connect through the expert or any other facts in the case to the night in question. He was in a car. There was a mere presence possibility because there was car trouble, because there was no fingerprints on any of these items, because there was no DNA evidence to connect him to any of these items. It was not his car. This expert could not in any way connect those phone conversations to this incident in question, and neither could any of the other evidence. So they were using prejudicial phone calls to say, look, this guy sounds like a drug dealer. We've got an expert who's going to tell you he sounds like a drug dealer. He must have known that stuff was in that car. That's why.
Did your client take the stand?
No, and we didn't put up any witnesses. This was not impeachment evidence. This was nothing.
Oh, no, I'm asking whether Mr. Campbell took the stand.
He did not.
Yeah, I might just suggest you probably know a lot more about this than I do, because you've been engaged in criminal defense work. But it seems to me every defendant has a perfect right not to take the stand. I mean, it's a right, and you know, counsel exercise that right in different ways. I would just suggest that when a defendant doesn't take the stand, it's a matter of tactics that runs an awfully big risk, particularly given the quantity of evidence that's coming in against him, not just on the expert, but Ms. Henderson has detailed a good amount of evidence that's coming in on what seems a pretty strong case, and I just think, as a matter of tactics or strategy, that Mr. Campbell might have some explaining to do. I just was wondering why he didn't take a stand, recognizing and respecting totally that it's your right to make and his right to make a strategic call not to.
And Your Honor, I mean, the only thing that I would say is that, yes, that is a very difficult decision, sometimes going to trial, but at the end of the day, the burden of proof is on the government to establish that this was not a mere presence case. He doesn't have to defend himself against that, Your Honor. And in this case, they did not have anything to overcome that mere presence defense, to show that he knew those things.
Well, one thing you would love for us to write an opinion that talks about a defendant not taking a stand as being of some value here, because if it is, I believe that's reversible error. I don't think that's something that is of any relevance for a defendant not to take a stand, because it's not his burden to prove himself guilty at any point.
And you can't have a prosecutor commenting on that. I don't think a prosecutor, obviously, I guess the case is Doyle. Obviously, the prosecutor did not comment on that. It can't.
And it's very difficult to even think from an appellate perspective that, we take in any consideration that the defendant did not take a stand. Judge, I think that's a tough one to walk on. They are given what we're dealing with. What we have is the cross-examination aspect of it, I think, is interesting. I do think that we're dealing with the admissibility of opinion testimony. And the question is, does the court have some duty in and of itself? Can it just hear an opinion testimony from someone that's qualified as expert, in which, in my view, the method or the reliability is not stated there? And of course, in Wilson, the court did go on to say, well, the defendant didn't object to those specifics as when it did not follow that, and therefore Wilson said it was harmless error, but it said it was error. That's where I'm going with it. So, but the defendant here says he did object to some extent. We'll have to examine to see to the extent that there is an objection here that meets the Wilson standard.
And if I could respond to a point that Judge Wilkinson made regarding the evidence that I realize that I'm over time. If I could make one final point.
Yes, you certainly may.
Thank you, Your Honor. You mentioned, Your Honor, the evidence or the level of the evidence that the government cited. I would like to point out that a great deal of what Ms. Henderson cited to Your Honor and the other judges had to do with other phone calls that are not issues on appeal here, that had to do with Mr. Campbell talking to other people about accepting responsibility for the gun that was in the car. And at no point did he admit that that gun was his or that he knew that was in the car. This was somebody on a jail who can't have a conversation with anyone but his lawyer that's not recorded. So he's trying to gather witnesses for his defense, somebody who may have known that this or left their gun in this car. Of course, the jury can take what they want with that. But I would also like to point out that the district court judge did sever the count of obstruction of justice from this trial. And so what you've got here is a guy who gets pulled over in a car that's smoking with burning radiator fluid, no evidence that he knew that these items were in the car. So the government has to pile on these months later phone calls to try to prove something that they just don't have proof of directly from that night. No admissions, no witnesses to say, look, he was out selling drugs that night. I've seen him with that gun. No fingerprints, no DNA.
Thank you very much, Mr. Cochran. And Judge Wynn, Judge Harris, you're welcome to ask any further questions if you wish.
Thank you, Judge Wilkinson. I have nothing further.
Judge Harris?
No, thank you.
Okay. All right. Mr. Cochran, Ms. Henderson, we thank you both and appreciate very much your arguments. And I'll ask the courtroom deputy to please adjourn court, and we will go directly into our conference.
Thank you, Your Honors.
Thank you, Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you now into the breakout room.